Oops. Happy Sunday. Happy Sunday, everyone. Forgot to put myself on screen. How are you? How is everyone? Today is Sunday. It is August 18th of 2024. I don't know where the whole month of August went, but it's another rainy Sunday here on the East Coast. And I feel like this summer's kind of been a bust weather-wise, I gotta say. We have had pretty much rainy, crappy weather most of the time. I think we've had 3 really nice summer days, and, seasonal affective disorder is a real thing. If you know, you know, but when it's rainy and it's gray all the time, it's depressing. It's depressing. The sunshine makes me happy. That's why I loved going to college in Boulder. And I stayed there. I loved it so much. I stayed there to go to law school at University of Denver because they have 360 days of sun a year. That's right, 360 days of sun a year. So even when it's snowing, it's sunny out. Oh, Patty, thank you so much for the Cash App so early in the morning. I appreciate you so. Yeah, it's been insane. It was crazy heat in July, like so much so that people couldn't even go out of their houses, older people, because they couldn't tolerate the heat. And, it's nuts. I was just watching Brian at LTL Media, and they were doing a standout, a free Karen Read standout in Dedham. There was about 25 people there with their signs on the side of the road. I don't know if it was a highway or a main road, but they were out there in the rain. I mean, that's dedication for justice, my friends. And so when you have the opportunity, go over there and give Brian at LTL a like. All the usual players were there. Rita was there. Uh, Full super moon tonight. I know, I'm feeling it. Anybody else feeling the full moon? I'm deeply affected. My moods are deeply affected by the planets and the moon. I don't know, maybe because I'm Aquarius, maybe that's what it is. But I am actually sensitive to it. Love Brian. Hi, Melly. Hello. Thank you, Moon Goddess. It is like a highway. And yes, it's a main route one. Yes, there seem to be lots of people going by beeping their horns. They were at Legacy Place in Dedham. And I think they just ended. I think they went until noon. Anybody else has further details on that? Of course, let us know. Ned loves drivel. I love the sound of rain. I listen to rain sounds when I go to sleep, but I just don't like seeing it outside every day. It's depressing. Oh, look at Moon Goddess. Definitely affected by the moon. Been this way for a couple of days for me. While we wait for a few people to come in and get ready, and because who knows if they even have their notifications working today. YouTube, thank you so much. Let's hear a word from our sponsor from today's show because it's a very timely sponsor. And I think I'm here to help, as always. I'm here to help, and I care about nothing more than your safety and your well-being. So let's listen to a word from our sponsor while we wait for some people to come in. If you would do me the indulgence, I would greatly appreciate that. Today's video is sponsored by Aura. And it's a really important time to be talking about them because hackers may have stolen the social security numbers of every American. Uh-huh. Over 2.9 billion records were stolen from national public data, which offers personal information to employers, private investigators, staffing agencies, and others doing background checks. These stolen records include a person's full name, address, date of birth, social security number, and phone number, along with alternate names and birth date. And members of this hacker group have reportedly released this information on the dark web for free. I don't know if you've ever had your identity stolen, but I've had clients who've had their identity stolen. And not only is it a major hassle, but oftentimes before you find out, it's too late. The damage can take years to undo, and it's a hassle that you definitely do not want to deal with. So if you haven't been taking precautions before with your personal information online, this should be a huge wake-up call. You've never been more vulnerable online than you are right now. But I'm not too worried about it because I use Aura. Aura alerts me if they find my phone number, my email, my social security number, or any other personal information on the dark web. They're going to let me know fast if anyone tries to use this information to access my credit or bank accounts. They give me up to $5 million in identity theft insurance should the worst case scenario happen. They also provide a bunch of other features to keep you safe online, all inside one app. And you can go to my link at www.aura.com/Melanie Little to try it for free for 14 days. That'll be enough time for Aura to find out if any of your personal information or data has been exposed. I highly recommend you do this right now, because not only is national public data not going to do anything to help you, they probably aren't even going to face any repercussions for this breach. I'm not leaving myself and my family vulnerable to data breaches. And if you don't want to either, you want to go to my link, www.aura.com/Melanie Little, to try 2 weeks for free. You can thank me later. You can thank me later. It's important. It's really important, because this is going to be a mess. And this is like the third one that we've talked about this year. We've talked about the one, the AT&T hack, and that was major. And now this is affecting every single American. So stay on top of it. It's a nightmare if you ever have to deal with it. And I'm here to help. Thank you so much to Moon Goddess loves this channel. Thank you so much for your super chat. I appreciate you so much. Mama She 13, thanks for the 10. I love the picture you have up for this live. I had to put the evil stepsisters in there because that's what we're dealing with. But thanks to the evil stepsisters, I think Ashley's got a really good shot at a new trial. And I'm going to tell you why. We're going to go over the motion. I'm hopeful. Because as you recall, when we were watching the closings, I stopped like every 3 minutes. And we were discussing, and I said, what are they talking about? None of this stuff that they're talking about was in evidence. They were like high school bullies. They were bullying her. They were trashing her in their closing. And it turns out that according to the Florida Supreme Court, prosecutors aren't supposed to be doing that kind of stuff. So we were right. We had a good right feeling. We had the right feeling about that. Our guts were right. Thank you, Mama She, for liking that. And Moon Goddess for liking the channel. Happy Sunday, Cupcakes. Says I'm just a girl in the world. On top of the super sticker. And Ricky Watson, howdy to y'all. And thanks for being a member for 6 months. The other day I did an impromptu 1 hour live on this. And what we learned, and I only had a couple of the documents then on Ashley Benefield. And we learned about that hoodie guy who was a YouTube user who was commenting in the law and crime chat during Verdict Watch about his sister potentially being on the jury and in the jury room, and snuck a cell phone in there and was texting him that it was 5-1 and the man was the holdout, etc. Thank you, Maureen Francis, for your Cash App and reminding me that I needed to turn off my notifications on my desktop. Thank you. We learned about that hoodie guy. We learned about Juror 15. And we learned in a not very detailed way things that Juror 15 may have perhaps lied about or concealed during voir dire and on her jury questionnaire about being a victim and a perpetrator of DV, which in a case like this is incredibly important. And I've got some more details on that for you today, the Juror 15 situation, and also the argument on prosecutorial misconduct. So we're going to look at it. I don't know anything about this letter. You guys keep talking about some letter. I don't know what this letter is about. What letter are we talking? Is the letter in the court file? Because I didn't see it. So I don't know what you guys are talking about. I do not know. So there's a couple of motions that are pending right now. One of them is a motion for a judgment of acquittal, which is basically saying, Judge, we want you to just overturn the verdict and declare that she's not guilty. Those motions rarely are granted because judges like to leave the finding of fact up to a jury. That's why we have a jury. That's why we have a jury system. In this case in Florida, there was only a 6-person jury because according to Florida rules, if it's not a capital case or a death penalty case, there is not a 12-member jury like we see in most cases, but a 6-member jury. And in this case, as you know, we discussed this at length, the 5 women, 1 man on the jury. And they stayed in court for 11 hours. They came back with the verdict the same day as the closings, and they compromised on manslaughter. So she's facing up to 30 years in prison. The motion that I'm more interested in here, because this is the one that I think has a better shot, is the motion for the new trial, request for interview of trial jurors and wait a second, is this the right one? Yeah, based on prosecutorial misconduct. So let's take a look at that. And unfortunately for you and for me both, we're going to need to play some of the closing statements, arguments from the stepsisters or the state prosecutors, because it's referred to in the motion, and I want us to go back and remember what was said. And so I have timestamps for that. Hi, you ready? And here we go. Lydia's. Aunt Lydia. We did refer to one of them as Aunt Lydia. I know. What a shame. Okay. This is the motion for a new trial, request for interview of trial jurors and incorporated memorandum of law. This was filed, I believe, on August 9th. I don't see any opposition papers to it yet. When they file opposition, I'll be sure to come back and do those with you as well. This is a motion for a new trial, request for interview of trial jurors and incorporated memorandum of law. Ashley Benefield, by and through undersigned counsel and pursuant to the 6th Amendment and the Due Process Clause of the 14th Amendment of the United States Constitution and Article 1, Sections 9 and 16 of the Florida Constitution, as well as Rule 3.600, A2B2, 458 of the Florida Rules of Criminal Procedure, hereby moves this court for a new trial. As grounds in support of the instant motion, Ms. Benefield alleges as follows. 1. Prosecutorial misconduct. The prosecutor's improper and inflammatory remarks during closing arguments prejudiced Ms. Benefield's substantive rights and warrant a new trial. Here's the legal standard. Under Rule 3.600B of the Florida Rules of Criminal Procedure, the court shall grant a new trial if got a frog in my throat. 5, the prosecutor was guilty of misconduct, or 8, for any other cause not due to the defendant's own fault, the defendant did not receive a fair and impartial trial. Rule 6.00B5 requires that the court grant a new trial where the prosecutor is guilty of misconduct that prejudiced the defendant's substantial rights. State v. Connell, which is a Florida case from 1985. Improper prosecutorial comments warrant a new trial where they deprive the defendant of a fair and impartial trial, materially contribute to the conviction, are so harmful or fundamentally tainted as to require a new trial, or are so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise. Citing Spencer v. State, which is a Florida Supreme Court case from 1994, that says the defendant's substantive rights are prejudiced if there is a reasonable probability that but for the remarks, the outcome would have been different. And that is citing the United States v. Wilson, a 1998 decision. The first argument here is, and we pointed this out when we heard this in closing, we were like, what? This was never in the record. This was not in evidence. False statements about Douglas Benefield filing for sole custody. During closing argument, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated, hold on, because I've got the receipts and we're going to go back and listen to it. Oh, except for I didn't want that to happen. Give me a second. Oh, here comes the rain. Hopefully the internet holds out. If I get a little bit wonky, let me know. She falsely stated this.
May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens?
Stop. Boop.
All of a sudden, she sidles up.
There you go. Remember that? I know you remember that because I remember that too. One day I'm going to get the hang of this technology, you guys, and it's going to be so awesome. This statement was entirely false and unsupported by any evidence presented at trial. In fact, the court docket shows that it was Ashley Benefield who filed a motion on May 4th, not Doug Benefield. The prosecutor further emphasized this false claim in her PowerPoint presentation displayed to the jury. Here's the PowerPoint presentation. You remember this as well. 9 of 2019, Doug finds out she's dating someone else. Doug files for divorce. Series of complaints start. No, 5 of them. No charges. May 1st, 2020, defendant files for another injunction. 5/4 of 2020, Doug files for sole custody. Seeing multiple therapists, Forrest Quintal, defendant acts different in front of Doug. Social outings, beach, movies, restaurants, pool. 6/1 of 2020, sent for evaluation with Dr. Broder, continues deception. That was part of her PowerPoint. This improper argument implied the state had information not presented at trial, suggesting Ms. Benefield was going to lose custody of her child, the final motive put forward by the state. Remember, that was their motive in the end. Because their first motive didn't pan out. Their first motive about Dr. Broder's report being released 3 days after the shooting turned out to be completely wrong. And Stephanie Murphy came in and testified about it. And then they brought in a witness to completely destroy Stephanie Murphy, who was Doug Benefield's lawyer at the time. So they had to pivot and they had to change their motive. And that's what they wound up with. Such comments referring to matters outside the record are clearly improper. As held in, and citing a Florida case from 1982, Wheeler v. State. As held in Williamson v. State from 1984, a prosecutor may not refer to facts not in evidence, as it constitutes a form of unsworn testimony not subject to cross-examination. Similarly, in Vaxek v. State, Florida case from 1985, and Lane v. State, 1984, the appellate courts held that it was improper for a prosecutor to refer to testimony or items not in evidence. There's a lot of case law about this, and I've read the cases. And if the judge does the right thing, I think she got a really good shot at a new trial. Given the highly prejudicial nature of this false claim about Mr. Benefield seeking sole custody, there's a reasonable probability it affected the outcome of the trial. Moreover, the improper comments deprived Ms. Benefield of a fair and impartial trial, materially contributing to the conviction, and were so harmful and fundamentally tainted as to require a new trial. It's raining men. Kelly, that's so funny because that's what I was thinking this morning. I'm like, it's raining, but it's not raining men. Raining again is what it is. Ms. O'Donnell's statement exceeded all acceptable bounds of advocacy and deprived Ms. Benefield of a fair and impartial trial. A new trial is warranted on this ground alone. C. Did we already do B? Hold on. Oh yeah, B was the false statements about sole custody. Okay. C. Improper attacks on and belittling of Ms. Benefield's character and identity. The prosecutors repeatedly and improperly attacked Ms. Benefield's character, calling her a manipulator at least 14 times during closing arguments, and claimed she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. Such vituperative characterizations of a defendant are improper and prejudicial. Look at this word right here. This is our word of the day. Vituperative. Never heard this word before, never used it in legal pleadings before. Here it is. Try and work it into your everyday conversation, because this is a fantastic word that means bitter and abusive. And I can't even think of a better word to describe the closing argument and rebuttal by the evil stepsisters than vituperative. So there's your word of the day: bitter and abusive. Citing Gore v. State, which is a Florida case from 1998. For example, prosecutor Suzanne O'Donnell told the jury, I'm going to go back now to footnote number 2 and pull up that clip.
The defendant trying to say he was in a fighting stance, he lunged at me. That is just her, once again, trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him.
You remember that. I know you remember that. During the state's rebuttal closing argument, Assistant State Attorney Rebecca Friel told the jury, let's get to that footnote, because that's a long speech by Rebecca, is that her name? Rebecca Friel?
The reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad.
Oh, wait, that's the wrong quote. Hang on one second. Oops, this is the one I wanted.
In the house. I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him.
Again, calling her a liar, hypothesizing about conversations. She must have been talking to him Like, where was this in the record? There was no evidence of that. You can't just start making stuff up in your closing. We watched this and we thought we were legitimately in the twilight zone. Every defendant is entitled to a fair trial. And let's listen to what she continues to say.
Telling him they're going to move to Maryland and live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that that mutual injunction was, I'm sure, Ms. Benefield was speaking to him when it was convenient for her.
I'm sure Ms. Benefield was speaking to him when it was convenient for her. You're not allowed to just say things that you're hypothesizing about that wasn't in evidence that you're sure about. Like, what is that? I'm sure they were talking. Yeah, exactly. This isn't about you, honey, says your mom.
But she could get something out of it. It only goes with the rest of it. This letter we've heard about that Ms. Benefield testified all these things.
Like, it only goes with the rest of it. I mean, these are her opinions. None of this was in evidence. It's completely improper for a closing argument. And you're not allowed to just trash the defendant based on your own personal opinions. You're just not allowed to.
It's another effort at manipulation.
Again, calling her a manipulator.
We don't know when she wrote that letter. We don't know what she put in it.
And that letter was not in evidence. Letter was not allowed in evidence. So again, she's opining and speaking on something that's not in the record. Makes me mad listening to this again. We don't know when she wrote the letter either because it wasn't allowed in. She wasn't allowed to testify about it. The defense tried to get the letter in and you objected and the letter was not allowed in.
I don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did.
You didn't have it. Not hear any testimony about the letter. Depends on the jurisdiction, Cricket. And I'm going to see what's in their opposition. Cricket says, please explain how any of this is objectionable after the fact. I don't get it. I thought everything she said was permissible since there was no objection at the time. Some of it is objectionable. It's in poor form to object during a closing argument. But it's still preserved for appeal. I'm pretty sure they made arguments after. Wasn't there another motion for a judgment of acquittal afterward? I don't know if you waive it, if you don't object during the closing in Florida. I'm a New York admitted attorney, so I don't know. I'm waiting to see what their opposition says. But the cumulative effect of all of these statements that were made, not just during the closing, but during this rebuttal and during the trial, may cumulatively entitle her to a new trial. Let's read on and let's listen on. But that is a great point. The defense did not object.
I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear?
She kind of did, right? Again, this is all her personal feelings. Like, she's taking this way too personally. We watch a lot of trials, we watch a lot of closing arguments, and I've never seen a defendant trashed so much in a closing argument based on the personal feelings of these prosecutors. It's just so unprofessional, such a bad look. The prosecutors did object during the defense closing, yeah. And the prosecutors manipulated the jury. Yep. Yeah, there is a motion to recuse as well. Coach Karen, we went over that the other day briefly. So if you didn't watch it, there's a stream I did a couple of days ago called Ashley Benefield trial juror misconduct. That's part of this motion as well.
About Dr. Liu and Mr. Haig. They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great.
She said, I don't even think she told them the same story she told you based on what they said. And then we go to footnote 4. Which is a different clip.
I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland and live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that mutual.
So in another part, she said, I guess that was the wrong clip, but she says, I would submit to you that those two experts, Mr. Haig was the one you should be depending on, even though he also spoke to Ms. Benefield. So clearly got one side of the story or a made up story. And then she goes on to talk about Dr. Broder. Yeah, okay, this is the right one.
Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down.
Again, this is all her just trying to trash the defendant for her own personal gain. It's beyond.
No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland, because then who's going to move her boxes, right?
Who's going to move her boxes, right? Moving on to the next. Clip, footnote 6.
And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew the jig is up.
Moving on to the next clip, footnote 7.
Doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. And she's trying to manipulate you.
And she's trying to manipulate you. That was footnote 7. These inflammatory attacks on Ms. Benefield's character served no purpose but to inflame the minds of the jurors against her. Such arguments are clearly prohibited. See Garin v. State, 1988 case, Bertolotti v. State, 1985 case. As the court stated in Chambers v. State, permitting this general attack on the defendant's character was error. That's a 2006 case. The prosecutors also ridiculed Ms. Benefield's testimony, with Ms. Friel stating, footnote 8,
Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser.
Wait, hold on, that's not the right clip. 654, 7. Oh, they put the wrong site in here. They put the wrong time stamp in here, so I'm just going to read it to you instead. The prosecutors also ridiculed Ms. Benefield's testimony, with Ms. Friel stating, you can decide what you think about her testimony. She's a witness like any other, but I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry and have to take breaks and you're racking, and then you're going to have a swollen face, and your eyes are going to be puffy, you're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney, told her, hey, there's tissues. Oh yeah, I should have a tissue. She'd been crying for 15 minutes, didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe she was a victim. She is not the victim. Douglas Benefield was the victim in this case. Emphasis added. Such vituperative, again, using the same word because it is in one of the cases that they cited. Actually, that's where they got the word. Such vituperative characterizations of a defendant are improper and prejudicial. As stated in Gore v. State, a prosecutor cannot engage in vituperative or pejorative characterizations of a defendant or needless sarcasm, revealing that the prosecutor has abandoned any semblance of professionalism. In the words of one viewer, these prosecutors sound like a couple of high school bullies. And that is so interesting because not only did some of you say that in our chat, but the footnote 9 refers to a Twitter account that watched the closing argument. So it was actually somebody's tweet. And I can't really click on that because it's a PDF. And we know that Jules was in the courtroom and she clearly pointed out to us that there were tears, that there was snot. So again, a mischaracterization and her own personal opinions that did appear, in my opinion, to be unprofessional. Still not enough. Still not enough. The prosecutors went even further and claimed Miss Benefield was lying with no evidentiary support. They said she told defense experts a made-up story, again without any basis in the evidence. Such attacks on the defendant's credibility are improper. As the court cautioned in Pacifico v. State, quote, where the case against a defendant is weak or tenuous, a prosecutor's contentions that the defendant is a liar could rarely, if ever, be construed as harmless error. And that's the Pacifico case. And the Pacifico case, which I read, is on point here because in that case, it was a young man who was convicted of forced intercourse, let's call it, for purposes of YouTube friendliness. And during that trial, there was a freshman at Florida State University who was essayed by what the prosecutors called, this is what their opening or their closing, this is what their opening was. This case is about an older, slick fraternity guy who targeted a naive freshman girl, tricked her into coming to his house, and then by physical force, insults, and threats, confined her there and forced her to have sexual intercourse against her will, leaving her with injuries to her sex organs described by the emergency room physicians as more severe than he had seen in most sexual battery cases. Based upon that and some other things that they said during the trial in this other case, Pacifico, during the closing argument, the prosecutor started their closing with, ladies and gentlemen of the jury, this case is about a chronic liar, a convicted felon, a sadistic, selfish bully who lied his way into a fraternity because he liked the social opportunities and the lifestyle that it offered him. He targeted a naive, trusting freshman girl. He tricked her into coming to his apartment by manipulation and ruse. Continuing in this vein, the prosecutor in that case said in his closing, the prosecutor advised the jurors that this defendant is a criminal and he needs to be convicted. And he went on and said some other things, but in my mind, Pacifico versus State is controlling. That person's conviction was overturned and he was granted a new trial. This goes back to what year is this? 1994. That's a Florida Supreme Court case. Seems on point to me. In Rosso v. State, a 1987 case, the court held that improper prosecutorial comments will warrant a new trial where the evidence is very close, where a prosecutor refers to testimony or items not in evidence, or where a prosecutor indulges in personal attacks upon an accused, her defense, or her counsel. D. Improper speculation about out-of-court conversations. Prosecutor Friel engaged in improper speculation about conversations between Ms. Benefield and Douglas Benefield, stating, let's see if we can get the proper footnote in here. This one is not footnoted. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but, co-parent. There was no evidence presented at trial that Ms. Benefield and Mr. Benefield were communicating while the mutual injunction was in effect. The prosecutors claim that, quote, they were, I'm sure, talking implies the state had information not presented at trial. Such arguments referencing matters outside the record are improper. See Wheeler v. State. 1982 case. E, false claims about defense expert testimony. The prosecutors made false claims about the testimony of defense expert Dr. Emma Liu. Prosecutor Friel stated, let's see if we can get the right footnote this time.
The medical examiner. She seems like a all the time.
Okay, it's about Dr. Liu.
Dr. Liu, the medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why did she do that? She did that because she's getting paid. She got paid to be here. That's why she's here. That's why she's saying those things. And most of them were probably very accurate.
Most of them were probably very accurate. We pointed this out as well. There was no evidence presented that Dr. Liu was being paid to testify or that she testified the way she did because she was paid. Ironically, at the time of her testimony, and as this is being written, Dr. Liu has received no fee whatsoever. The prosecutors never even asked Dr. Liu if she was being paid. This improper argument suggested, without any foundation in the record, that the defense had suborned perjury from their expert witness. Such comments are highly irregular, impermissible, and prejudicial. Henry v. State, 1995. Moreover, the prosecutors improperly denigrated the defense theory and expert witnesses. A prosecutor may not ridicule a defendant's theory of defense. Citing Riley v. State, 1990. In Rosso v. State, 1987, the court held that improper prosecutorial comments will warrant a new trial where the evidence is very close, where a prosecutor refers to testimony or items not in evidence, or where a prosecutor indulges in personal attacks upon an accused, his defense, or his counsel. F, improper appeals to emotions and sympathy. The prosecutors made inflammatory arguments clearly designed to arouse the emotions and prejudices of the jury against Ms. Benefield. For instance, Ms. O'Donnell emphasized make sure this is the right one. Oh, this is 11 and 12. All right, well, let's let this play through.
And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. You know, I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No.
Okay, we take it to 5. 23:39.
Came at her with a club, never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child.
Such arguments that serve only to inflame the minds of jurors are improper. As held in Bertolotti v. State in 1985, closing arguments must not be used to inflame the minds and passions of the jurors so that their verdict reflects an emotional response to the crime or the defendant rather than the logical analysis of the evidence in light of the applicable law. In Garin v. State, 1988, and Gonzalez v. State, 1991, the courts held that arguments that have no purpose but to inflame the minds of the jurors against the defendant are clearly prohibited. See also Rosso v. State, 1987, discrediting a proper legal defense instead of commenting on the evidence and the reasonable inferences therefrom. Taylor v. State, 1994. Improper burden shifting. This is something else that we pointed out as we were listening to this. The prosecutors repeatedly misstated the law on self-defense, telling jurors they needed to evaluate whether Ms. Benefield's use of force was reasonable and necessary. For example, Ms. O'Donnell stated,
The real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are two words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately.
Ms. O'Donnell further shifted the burden of proof impermissibly in closing argument when she highlighted and emphasized the incorrect instruction in her PowerPoint presentation displayed to the jury. Here's the screenshot of the PowerPoint. Self-defense, justifiable use of deadly force. Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm or a foreseeable felony. During rebuttal closing argument, Assistant State Attorney Rebecca Friel again argued I know it's painful, but we have to do it.
The part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead, the death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the second degree with a firearm. Thank you.
This argument improperly shifted the burden to Ms. Benefield to prove her actions were justified. The self-defense jury instruction clearly states Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. That is the Florida Standard Jury Instruction. As held in Brown v. State, 1984, and Hernandez Ramos v. State, 1986, the state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. A defendant has a fundamental right to present a defense, see Story v. State, 1991, and to have the jury properly instructed on any legal defense supported by the evidence, Gardner v. State, 1985. These rights stand for naught if the prosecutor can ridicule a defense so presented, denigrate the accused for her determination in raising the issue, and misstate the law in contradiction of the judge's instructions, as the prosecutor in this case did. The error committed by the prosecutor in closing argument, therefore, deprived Ms. Benefield of her fundamental right to a fair trial. With ample evidence to support the defense of justifiable use of force, it cannot be said that the error was harmless beyond a reasonable doubt. Citing 2 other cases from 1986 and 1998. H, false representation of wound path. The uncontroverted testimony was that the wound path of the fatal shot to the decedent's chest was from front to back, left to right. We talked about this as well while they were arguing it in closing. Such was the testimony of Dr. Vega, the state's medical examiner. That wound path description was confirmed by Michael Haig, the defense's ballistic expert, as well as Dr. Emma Liu, the defense's physician and just retired Miami-Dade County medical examiner. Despite that, and using a graphic illustration, never at any time prior shown to the defense, the state, through Assistant State Attorney Suzanne O'Donnell, represented to the jury that the wound path was side to side. And here is what she said.
So I want to talk a little bit about this trajectory, just because there's sort of some misconception that this shot was front to back.
I think the misconception was yours, counselor.
That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is.
And this was the graphic they didn't show to the defense prior to their closing?
The bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, the right-hand side, and that red dot is where it landed in the back.
In an even more blatant misrepresentation, Ms. O'Donnell used a graphic depiction, Exhibit E, we just saw that, to demonstrate that the wound path entered the deceased's right side behind his right arm, traversed his chest in a straight path, and lodged in his back. This was a flat-out misrepresentation of uncontroverted testimony, which clearly misled the jury. I, cumulative effect. While no single improper comment may require a new trial on its own, the cumulative effect of the prosecutor's numerous improper and inflammatory remarks deprived Ms. Benefield of her fundamental right to a fair trial. As the court stated in Johns v. State, while no one of the comments standing in isolation would have required a new trial, this court must look at the entire trial record when considering whether the comments at issue are of such a nature as to destroy the families of the proceeding. I'm sorry, that doesn't say families, that says fairness, as to destroy the fairness of the proceeding. When considering the relative lack of evidence against Johns, that's the case they're talking about, the character of the evidence that did exist, and the number of improper arguments made by the prosecutor, it's apparent that the prosecutor's closing argument was improper with respect to the neutral arena in which a trial should be held. That is a Florida case, 2002. As stated in Chambers v. State, 2006, in order to require a new trial based on improper prosecutorial comments, the prosecutor's comments must either deprive the defendant of a fair and impartial trial, materially contribute to the conviction, be so harmful or fundamentally tainted as to require a new trial, or be so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise reached. The prosecutors in this case repeatedly made inflammatory and improper comments attacking Ms. Benefield's character, referencing matters outside the record, making false claims about the evidence, appealing to sympathy, and shifting the burden of proof. Given the nature of the evidence in this case, these inflammatory and improper comments affected the outcome, deprived Ms. Benefield of a fair trial and impartial trial, materially contributed to the conviction, and were so harmful or fundamentally tainted as to require a new trial. As held in DiGiulio, to establish harmless error, the state must show beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated, that there is no reasonable possibility that the error contributed to the conviction. The state cannot meet that burden here. A prosecutor's concern in a criminal prosecution is not that it shall win a case, but that justice shall be done. Modica, quoting Berger v. United States, it's a U.S. Supreme Court case from 1935. That's how old that premise is, that we're supposed to be interested in justice, not winning. That's what a prosecutor is supposed to be doing. While a prosecutor may strike hard blows, she is not at liberty to strike foul ones. The prosecutors in this case clearly failed to honor these precepts. Their conduct also violated the obligations imposed by the Florida bar. In short, the prosecutors exceeded all acceptable bounds of advocacy. It is appropriate here to reiterate the jurisprudential principle expressed in Pacifico that, quote, the cornerstone of our system of justice is the right of an accused to be fairly judged by a jury of his or her peers. On the record in this case, the repetitious and egregious nature of the prosecutorial improprieties became such a feature of the trial as to deprive Ms. Benefield of that fundamental right. In this regard, the state cannot demonstrate beyond a reasonable doubt that the prosecutor's comments impugning Ms. Benefield and her defense did not contribute to the verdict, citing DiGiulio. Finally, in this case, the prosecutor's references to Ms. Benefield as being a liar, a manipulator, and to matters for which there was absolutely no support in the record, in a manner both pejoratively and sarcastically, all of which form the basis for Ms. Benefield's motion, were so invasive and inflammatory, quote, it is questionable whether the jury could put aside the prosecutor's character attacks and decide the case based strictly upon the evidence. Thus, in situations where witness credibility is the pivotal issue, inappropriate prosecutorial Blah, 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 blah. Thus, in situations where witness credibility is the pivotal issue, inappropriate prosecutorial comment, which might be considered harmless in another context, can become prejudicially harmful. Citing Hill v. State, 1985. As emphasized in Bass v. State, 1989, when the case presents a two-witness swearing match where there is little or nothing to corroborate the testimony of the witnesses, witness credibility is pivotal. An inappropriate prosecutorial comment, which might be found to be harmless in another setting, may become prejudicially harmful. Because the present case chiefly involved the testimony of Ms. Benefield, the undeniably crucial issue was the juror's perception of Ms. Benefield's credibility. Let's take a break for a moment and look at some questions with regard to that part of the argument. Dewey, thanks for the 5. Truth revealed on YouTube. Episode Higgins butt dial around minute 28 says Ashley Benefield was truthful. Wait till I'm done to look. Yeah, wait till I'm done to look. But we've been over a lot of his material before, and he has a couple of videos on Ashley as well. So I don't know if you're telling people to look at Higgins but he's also got some videos about Ashley as well. Intolerant member for 4 months. She could get a murder conviction in a new trial. She could, but she's facing up to 30 years on manslaughter. I would submit to you it's worth the risk. David Reese, thanks for the 5. Eva posted an email on TikTok that was supposedly sent to the judge claiming that Ashley tried to hire him to do the deed. Thanks, David. I don't know if it's not in the court record. I'm not gonna put it up here. As rumor, speculation. I like to deal in facts. So unless someone can tell me that it's part of the court record, I'm not gonna entertain it. But thank you. Kathy says, thanks for the 5. So happy this is happening. I can't help but feel it's a remedy for the miscarriage of justice. Well, I think the second argument that we're going to get to here is even better. So rest assured that in Florida, the Florida Supreme Court has said that prosecutors can't do that. What they did was totally improper. We were right. Fab Shelley says, Melanie, the judge knows the rules and he didn't stop the prosecutors on closing from attacking. He won't issue a ruling in Ashley's favor on this case. I'm not hopeful that he will, but that's why we have appellate courts. And that's why we have other judges who review cases such as this. The case I told you about before, Pacifico, went to the Florida Supreme Court. And another case that they cite, Gore versus State, which is a case from 1998, which was another Florida Supreme Court case. This was a case regarding a death penalty case. This was a death penalty case where this guy Gore was tried in 1995 for the murder of Robin Novick, last seen alive in 1988, in the company of a white male resembling Gore. In the early morning hours, Gore was seen of the date of the next day, the day after her death. Gore was seen driving Novick's automobile, which he later wrecked and abandoned. So this was a death penalty case, and it was overturned. Let me just go down here and see what the prosecutor said. The prosecutor twice exhorted the jurors during closing argument to convict Gore if they disbelieved his testimony. And this is what the prosecutor in that case said in closing. You see, when I started with you, I told you I have the burden of proof, and I always have the burden of proof. But you see, now you consider all the evidence presented to you and decide whether I met not just the evidence I presented, but the evidence they presented, you see, because I'll make it really simple for you. If you believe he did not tell you the truth, that he made up a story, that's it. He's guilty of first-degree murder. Instead of standing up here for the next however much time I have left, 25 minutes, and just talking about ridiculous statements, which I don't want to anymore, Okay, we've listened to everything. I can't give you anything else that you haven't heard. I can't make this any more simpler than it is because that's what it is. It's simple and it comes down to this in simplicity. If you believe his story, he's not guilty. If you believe he's lying to you, he's guilty. It's that simple. And then the Supreme Court of Florida went on to say, while wide latitude is permitted in closing argument, this latitude does not extend to permit improper argument. Here, the prosecutor's closing argument enunciated an erroneous and misleading statement of the state's burden of proof because it improperly asked the jury to determine whether Gore was lying as the sole test for determining his issue of guilt. They also, in that case, had personal attacks on Gore. And at some point, the prosecutor said, because the prosecutor said something like, at some point in this trial, the prosecutor allowed his animosity towards Gore to overcome his professional judgment and responsibilities. Apparently, because the same prosecutor had previously been involved in prosecuting him, Gore questioned the prosecutor as to whether the prosecutor had a vendetta against him and why the prosecutor continued to prosecute cases against him. The prosecutor responded, because I don't like people who kill women. How's that? You want to know why? Because I don't like people preying on women. Later in the cross-examination, Gore challenged the prosecutor to take the stand, to which the prosecutor responded, I didn't kill 3 women, you did. You see, Mr. Gore, you killed women. That's why you're on the stand. I think that's very similar to the case that we have here and the things that these prosecutors said about Ashley Benefield and her testimony. So tell me what you think. Athena, please address the topic of why the second prosecutor did not deliver a proper rebuttal argument. Her argument should have addressed what Taylor presented in his closing. I agree. We talked about that during the trial. They don't bring it up in this motion. Maybe in the other motion, but I haven't seen it. So if you've seen it somewhere, let me know. Her argument should address what he presented in his closing. That's what I said too. But I don't know enough about Florida rules to opine on that, Athena, right now. But thank you for the super chat. Dewey, Mel, I don't know what that says. I love the sarcasm in your voice because it comes through to me as like a little square that has an emoji. I love the sarcasm in your voice when you say, counselor. My grandmother used to say, a lady never offends someone unintentionally. Classy. Counselor. Moving on to the next and what I think is the better argument, which is identifiable juror misconduct. Juror 15, Sarah. We're just going to call her Sarah. I've redacted her name, but she's got 3 names, which is why I think that this is accurate. Failed to disclose on her questionnaire material information and further concealed material information during voir dire that would have resulted at a minimum in a peremptory challenge by the defense. Here's the legal standard. The Florida Supreme Court has laid out a 3-part test. No, don't do that to me. I don't like that view. Three-part test for determining whether a juror's non-disclosure of information during voir dire will warrant a new trial. First, the complaining party must establish that the information is relevant and material to jury service in the case. Second, that the juror concealed the information during questioning. Lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence, citing a bunch of cases. Any juror who conceals a material fact that is relevant to the controversy is guilty of misconduct, and this misconduct is prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. The presumption of prejudice has been said to apply unless the opposing party can demonstrate there is no reasonable possibility that the misconduct affected the verdict. That's where I think the state's going to get hung up on this, because we're going to read on to see what this juror concealed and failed to disclose during jury selection. Under the rule, a criminal defendant is entitled to a new trial if a juror's misconduct has prejudiced the defendant's substantial rights. The substantial right implicated in this case is Ms. Benefield's right to be tried by 6 impartial jurors and her right to challenge the juror for cause or make a peremptory challenge. Thus, it is the duty of a trial court to see that defendants in criminal cases are tried by a jury such that not even the suspicion of bias or prejudice can attach to any member thereof. If there is any reasonable doubt as to whether a particular juror can render an impartial verdict based solely on the evidence presented and the law announced at trial, that juror should be removed, even if the juror affirmatively states that he can be impartial. While challenges for cause permit rejection of jurors on a narrowly specified, provable, and legally cognizable basis of partiality, the peremptory permits rejection for a real or imagined partiality that is less easily designated or demonstrable. Once Ms. Benefield has established juror misconduct, she is entitled to a rebuttable presumption of prejudice and thus a new trial, unless the state can demonstrate that any prejudice was harmless. The harmless error analysis places the burden on the state as the beneficiary of the error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated, that there is no reasonable possibility that the error contributed to the conviction. B, the concealed information was relevant and material. The information concealed by Juror 15 is highly relevant and material to this case. As the Florida Supreme Court has noted, relevance and materiality necessarily turn on the facts and circumstances of each case. The Fifth District Court of Appeal has explained that a juror's non-disclosure of information during voir dire is considered material if it is so substantial that if the facts were known, the defense likely would preemptorily exclude the juror from the jury. Juror 15 failed to disclose and or otherwise concealed the fact that 1, she was a victim of domestic battery on February 20th of 2016 when her live-in boyfriend, Albert, intentionally slapped her in the face with an open hand 5 times. And they attach that as an exhibit. And I've read the exhibits. I'm not going to put them up, but the facts are accurate, I will tell you. Number 2, her son Hayden was charged with felony battery against his pregnant girlfriend on August 31st of 2014. And Juror 15 was the bond depositor in this case. So that proves that she knew about it. 3, she was the respondent in multiple petitions for injunction for protection against Stevie filed by her ex-husband Charles, seeking protection for himself and their minor child, who I'm going to tell you is that same child, Hayden, who wound up being charged with felony battery of his pregnant girlfriend years later. On grounds similar to those put forth by Ms. Benefield against the deceased Douglas Benefield specifically, Juror 15, number 1, Juror 15 was a respondent in a petition for injunction for protection. That's what used to be called a restraining order. Some places it still is. In Florida, they now call it a petition for injunction. So it's an injunction petition. Filed on September 2nd, 2003 by her ex-husband Charles, seeking protection for himself and their minor child, HJW, in the 12th Judicial Circuit Court in Manatee County, Florida. A copy of his name is Charles's petition is attached here too as Exhibit H and alleges in part 1, threatening and violent behavior by Juror 15, including cussing, slamming doors, and throwing objects. 2, a suicide attempt by Juror 15 on July 18th, 2003, resulting in hospitalization. 3, constant harassment and threats to Charles and his wife. So at that point, Charles had been remarried. 4, fear that juror 15 might harm their son in a future suicide attempt. 5, request for supervised visitation until juror 15 demonstrated mental and financial stability. Number 2, juror 15 was also a respondent in another petition for injunction for protection against DV filed on April 23rd of 2004 by her same ex-husband, Charles, seeking protection on behalf of their minor child, HJW, in the 12th Judicial Circuit Court in and for Manatee County, Florida. A copy of that second petition is attached and alleged in part 1, physical abuse of the minor child by juror 15, picking the child up by the arms and slamming him against a wall. 2, the child expressing fear of returning to juror 15's home. 3, a child abuse report filed with the Bradenton Police Department. 4, threats by juror 15's boyfriend to kill her ex-husband, Charles. 5, an ongoing CPS investigation. 6, the child showing signs of becoming violent. That is heartbreaking to me because this same child, 10 years later, wound up being charged with abusing his pregnant girlfriend. And the cycle of DV continues. If you know, you know. These undisclosed facts are strikingly similar to the prosecution's theory against Ms. Benefield and would have raised serious concerns about juror 15's ability to be impartial. The domestic violence allegations against juror 15, including claims of threatening behavior, violence against a child, and concerns about mental stability, mirror key elements of the state's case in this instance. As noted in Fine v. Shands, the focus should be on what appellant's counsel would have done during voir dire had the litigation history of the juror been disclosed, rather than on whether the court believes the jurors were actually biased. Given the parallels between juror 15's concealed history and the facts of this case, this information implies a bias or sympathy for the other side, which in all likelihood would have resulted in the use of a peremptory challenge. The defense would have undoubtedly exercised a peremptory challenge to remove juror 15 had this information been disclosed. And I agree with that 100%. Moving on, C, the juror concealed the information during questioning. Juror 15 concealed this information both on her jury questionnaire and during voir dire. On the questionnaire completed under the penalty of perjury, she falsely indicated that neither she nor a family member had been a victim of a crime. During voir dire, when asked about child custody issues, domestic violence, and involvement with injunctions, juror 15 remained silent. The Florida Supreme Court has held that a juror's non-disclosure need not be intentional to constitute concealment. Citing Roberts, whether intentional or not, juror 15's omissions prevented counsel from making an informed judgment, which would in all likelihood have resulted in a peremptory challenge. D, the failure to disclose was not due to lack of diligence. The defense exercised due diligence in questioning potential jurors. Both the state and defense asked sufficiently specific questions about child custody, DV, and injunctions. These topics are within an average juror's understanding, and juror 15's failure to disclose cannot be attributable to any lack of diligence by the defense. As stated in Bowling v. State, 2011, the test for juror competency is whether the juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions given. If there is any reasonable doubt about a juror's impartiality, the juror must be excused for cause. Here, the concealed information is highly relevant and material to this case, was clearly concealed during questioning, and the failure to discover it was not due to any lack of diligence on the part of the defense. These similarities between juror 15's undisclosed experiences and the facts of this case create a substantial likelihood of bias or sympathy, or a real or imagined partiality that would have resulted, at worst, in a peremptory challenge, if not for cause, had the information been disclosed. And I completely agree with that argument. The receipts are all attached as exhibits to the motions. This is all, in fact, true. There's enough identifying information on the documents to identify this Juror 15 as the person named in these complaints. And in my opinion, it's a big problem. The next, they go into the unidentifiable juror misconduct, which we talked about more at length the other day in the other stream. So I'm not going to repeat everything here, but they talk about an unknown juror bringing a cell phone into the jury room and using it during deliberations. And that obviously that's in direct violation of the court's instructions and Florida law prohibiting unauthorized materials in the hoodie room. And then there was a YouTube user named That Hoodie Guy who posted comments in the law and crime chat during verdict watch. And they say these comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. And the comments say, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, That Hoodie Guy posted a comment stating verdict incoming. At 10:25 p.m., That Hoodie Guy posted a comment stating, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. At 10:27 p.m., That Hoodie Guy posted a comment stating, my sister snuck a flip phone in. At 10:28 p.m., That Hoodie Guy posted a comment stating, I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. At 10:28 p.m., That Hoodie Guy posted a comment stating, my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. At 10:30 p.m., a mere 2 minutes after That Hoodie Guy posted that the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that That Hoodie Guy's information originated from within the jury room during active deliberations. Accordingly, Ms. Benefield has formally requested the court interview the jurors in the presence of the parties. So this is what we're seeing in Karen Reed. This is what we saw in Murdoch. This is what we saw in the Maya Kowalski case. Defendants are asking for juror interviews after the fact. Then they go on to state the standard and the reasons why that they think that they should call the jurors back in and interview them. And they say that the presence and use of a cell phone in the jury room during deliberations is a clear instance of juror misconduct. And they cite some cases for their position because they say that someone can use a cell phone to look at outside information, contact with the outside world, etc. And under Florida law, once juror misconduct is established, there is a rebuttable presumption of prejudice. The burden then shifts to the opposing party to demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. They say in this case, the presence and use of a cell phone during deliberation creates a probability that the jury's decision-making process was influenced by unauthorized information. Unlike the automobile magazines in Hamilton v. State, which were deemed irrelevant to the legal and factual issues of the case, the cell phone provides potential access to a wide range of information directly relevant to the case at hand. Wherefore, Ms. Benefield praised that following an evidentiary hearing wherein the court recalls the jury and allows them to be questioned by the parties, the court grant her a motion for a new trial. XO, Neil Taylor for the defense. What say you? Appeals take a long time. With regard to the prosecutorial misconduct, that appeal could take a long time, depending on the decision of the trial judge, which I tend to agree with. The trial judge may disagree with that. But I think that the juror argument is a very good one because the things that the juror concealed are exactly the subject of this case. And if I was picking a jury and I had and a juror was truthful about that, having been the perpetrator or the alleged perpetrator, the accused perpetrator of DV in 2 separate cases, and then the victim of DV in another case, and then her son also being accused of DV, for which she posted bond, so she couldn't say she didn't know anything about that. If I were picking that jury, I would certainly inquire more of the juror to determine whether or not they could be impartial. I would challenge that juror for cause. And if the cause challenge failed, I would absolutely use a peremptory on that juror because I would not want that juror on the jury. And I don't think the state would either. The state may consent to that because they may say, oh, this person was a victim and a perpetrator. We don't know which side they're going to have bias towards. And so therefore, we don't want them on the jury either. So that is interesting. Hi, Stephanie. Stephanie says the juror argument is excellent. You're probably talking to this, comma. And so is the recusal of the judge before sentencing. Hi, Jamie. Attorney Jamie. Order of appeal. Chances, in my opinion, gold, juror with abuse history, silver, prosecutorial misconduct, bronze, hoodie guy. But they're all metal contenders. Yeah, I agree with you. But I think that hoodie guy on his own, I don't think that's enough. But I think when you put all this stuff together, Jamie, do you practice in Florida? And if you do, if we have any practicing Florida attorneys in the chat, I want to know if you don't object during closing if it's waived. I think the argument here would be that it is what this is the cumulative effect of everything that happened in the closing and not just one specific thing. So I agree with you on your Olympic medal analogy. Yeah. People keep talking about this metal. Aren't there metal detectors? Yeah, there's metal detectors, but you put your cell phone in a little bin, and typically the juries are allowed to have their cell phones with them. They just have to keep them outside the room when they're deliberating. They have I don't know if they have lockers for them in Florida in this courthouse. I don't know. But they have a place for them to leave their things, and they're not supposed to bring it in the room. So yeah, I don't know. People have this whole metal detector argument that's not really valid in my opinion because you're allowed to bring them in. You're just not allowed to bring them into the room. Kathy, will juror 15 receive any sanctions? She should. That would be up to the judge. I mean, you're filling out that questionnaire under penalty of perjury. I don't know that a juror has ever been held to sanctions. Can you think of a case where they were? Thank you, Kathy, for the deuce. See if you guys have any questions in the chat. Wow, just wow, Danielle. Danielle, I've been hanging out with you all day. Didn't I just see you over at Brian's stream for the Dedham standout? Wednesday, I know. So much ADHD in these chats. Who else wants to have a conversation with 1,800 people at the same time as listening to someone whose commentary we love? I know there's at least a dozen conversations usually going on in this chat. This chat is amazing, and I love this chat. And what's so nice about this chat is that you guys are so supportive of each other. Somebody will say something like, I'm listening to you while going through chemo, and then everyone in the chat will put up prayer hands and talk to that person and root for them, and it's really great. Charistity says, I hope they made great arguments on all of it, but my faith in justice is low right now. That's why we had to move over to Vegas and cover this boss baby Robert Telly's trial, because it seems to me to be cut and dry. I mean, we're waiting to hear the defense theory, but the judge is amazing. So if you have little faith left in watching trials, come with us to Las Vegas tomorrow. We're going to start at what time are we starting tomorrow? 1:30, I think. 1:30 Eastern, 10:30 Pacific, to watch attorney Robert Tellis, politician, public official, being tried for the murder of an investigative reporter named Jeff Garriman, who wrote some hit pieces about him. Okie dokie says, why can't people just follow the damn instructions and rules? This stuff costs the taxpayers a lot of money. They should be held personally liable for the expense, in my opinion. Stephanie agrees and says, Juror 15 should pay for a second trial. I don't know. Maybe this juror thought they'd never find out. No harm, no foul. It's crazy, right? Melissa says, with all the misconduct, why can they not release her ASAP? Because they haven't proved it yet. Wednesday says there should have been more jurors and a longer trial. I completely disagree with the 6-person jury system in Florida. I don't know why that is. Especially murder, facing up to 30 years. Real Alien Superstar says this is wild. It is. Anthony, if them comments aren't true, that still doesn't leave out juror 15 lying. Yeah, to me, that's the biggest problem. To me, that's the best argument. Dear Dad, I don't know. I thought the hoodie guy had been exposed as a fake and a troll. I don't know. I don't know anything about that. Maybe we'll hear from that in the responding papers from the state. But kind of curious, right? That he would have all that information like 2 minutes before they're coming out with a verdict that they, came to at something like 10:30 at night. Margaret says, can we trust a jury now? I've seen a lot of chatter about this in the comments. You guys are debating with each other respectfully. So thank you for doing that, for being respectful. And many people are saying we should have professional jurors. And then other people were saying, yeah, but that opens up the door for more corruption. And then other people are saying, you guys have a lot of great opinions and you're sharing them respectfully. And listen, back in the day when all this stuff when our system was invented, you were meant to have a jury of your peers. And back then, all the way back then, our founding fathers, the jury of your peers would be everyone who lived in the same town that knew you, right? It's not really like that anymore. I don't think professional juries are the answer. I don't know what the answer is. But I find the whole thing frightening. Lori, $350 for Lori Life 360 for the win. Thank you for your $50 super chat. You're amazingly so generous to this channel. Thank you. I'm humbled. I was selected for jury duty. It was a child abuse case by a boyfriend babysitter. He claimed under the influence. My daughter had just died of an OD and I was raising her children. It was a no, definitely not. Guilty in my eyes. Oh my goodness. No, it was a guilty in your eyes. It was a no, definitely not. Guilty in your eyes. I'm so sorry about your daughter. My prayers and thoughts go out to you. Nobody should ever lose a child. That's horrifying. And you're raising her children. You're the greatest mom and grandma in the world. That makes me very teary-eyed. Thank you for doing that for them. Pilgrim Shadow says, thanks to the mods for all your work. Thank you, Pilgrim Shadow, for your 20. No Grateful Dead quote today? We need some Grateful Dead quotes to uplift us a little bit. Owl Salt. I'd advocate for not for professional jurors, but better education about the judicial system for all citizens. Here's where I stand on this. I think the jury instructions need to be revamped. I think the jury instructions are not good enough. I think that we can't expect that jurors are lawyers. They're not. They're lay people. We can't expect that jurors sit home like we do and watch YouTube trials all day or listen to them while we're at work or while we're driving. The average juror does not know in Florida that you're allowed to ask for a read back. That's another argument in one of their motions. The instructions need to be changed. In the Karen Reed trial, the jury should have been instructed, if you come to a verdict on any of the counts, Please let us know. They did not know that. The allegations in the Karen Reed case are that several of the jurors have come forward to say we acquitted on counts 1 and 3. We just were hung on count 2, but nobody ever asked us that. So therefore, the judge just declared a mistrial real quick, didn't ask the jury if they had come to a consensus on any of the counts, and declared a mistrial. So why aren't juries instructed better, more clearly, more concisely? These jury instructions are hella confusing. And I'm an admitted attorney with 30 years experience as a trial lawyer. And in the Karen Reed case, the jury instructions were incredibly confusing. I think the jurors also need to be instructed when they're filling out their questionnaires that if you lie on your questionnaire and you withhold something, you're filling this out under penalty of perjury. And you could be prosecuted for perjury. How about you just get up there and tell the truth? And when you're questioned about it, you say, listen, I can't be fair. Here's why I can't be fair. I can't be fair because this is a topic that's too close to my family, my heart. I know people. I can't be fair. I mean, that's all we want in this system are jurors who can be fair and who can put aside any potential bias that they may have. But if you can't put aside your potential bias, then you should just say so. I can't be fair. And you'll be excused for cause. But I do think that everyone should try and serve on a jury at least once. I think it's an eye-opening experience. And I think it's an amazing public service, and professional juror has even changed their name to professional juror, says, I'm ready for the job. Many other countries have professional juries or no juries. I just read something about a woman, and I think it was somewhere in Russia. You can tell me in the chat because I know you probably know better than I do. And she made a donation of something like $51, I think, to the Ukraine. Maybe I have my details wrong. And she was just sentenced to something like 12 years in jail or prison in like a Russian prison. Like, if anybody knows the exact details on that, let me know. But that's the way other countries' systems work. So I don't think that we can, $53. It was $53. And is that right? 12 years in prison? Margaret says in the Netherlands, we have no jury, only judges. JP. Melanie, I've been a lawyer for 30 years. Are you the Doogie Howser of law? No, I just have a really good ring light and an HD camera. But thank you. Thank you very much. I wish. Christy says the jury instructions were 52 plus pages long. Right. Is there a need for that? I think some things need to be more clear. I think, jury instructions are drafted by committees of lawyers, right? So, is there too much legalese in there? Do they need to be simplified a little bit so that the average layperson can understand them? And if we're really looking for justice and not just a conviction, shouldn't we offer a readback? Or shouldn't we listen? It's on YouTube. Everything's videotaped and it's not videotaped. Everything is streamed on YouTube. Can't you just play that portion of the person's testimony back and let the jury watch it? Like, what's the harm in that? Without the chat on, of course. Because don't we want them to come to the right decision and not have to guess and rely on each other's notes and memories? And Mike is like, what do we have to do? Give jurors lie detector tests? I don't even think lie detector tests are accurate or reliable. Russian ballerina. Thank you, Laura Christine. 12 years. Ridiculous. For donating $53 to the Ukraine? Like what? I mean, that's what you get when you go to other countries. Like Brittany Griner. Like, you don't know. Don't carry stuff in your luggage. Don't get arrested in a foreign country. I saw a movie when I was a kid. I don't know how old I was, actually. It was called something like, I want to say like Broke Down Palace, about two girls who went to Thailand and some guy, like that was a boyfriend of one of them or a friend, gave them something to hold in their luggage, kind of like a Midnight Express type thing. And they were sentenced to prison in Thailand. And it horrified me for the rest of my life. I'm like, you better check your luggage every time you go somewhere and make sure you have nothing in your luggage that could get you in trouble. No, not every other country is bad. I'm not saying that. I'm saying be careful when you're traveling. You don't want to wind up and then have to rely on the US government to get you out of there. I'm not. Did I say every other country is bad? I don't think I said that, JP. I don't think I said that. Thank you. One step beyond you. I know you guys are so good with the Google and you help me in this collaborative. A Russian court has sentenced amateur ballerina Ksenia Karolina to 12 years in jail for treason for donating $51. I was right about the $51 to a charity supporting Ukraine. WTAF. Jamie says, can always choose a judge, but our law provides for a jury of our peers. Yeah, but in some jurisdictions, judges are appointed, like in Massachusetts. Judge Cannoni was appointed by the governor very long time ago. In New York, we elect our judges here. Federal judges are appointed, but our state court judges are elected. And it's so important to vote in elections that are, off-year elections. It's so important to vote for judges. You need to do your due diligence and you need to find out what they stand for, what they've ruled on. Unfortunately, Midnight Express, yeah, that was a different movie, but this one I think was called Broke Down Palace. You've been scared ever since too, Hippie Chick? Me too. Scared the bejesus out of me. The conditions that those girls were in that prison. Claire Danes was in it. Yes. Yes. Thank you, Shaka and Huara. Yeah. Michael's like, don't bring a bullet to a foreign country in your luggage. Yeah. Magnolia Gypsy, you saw it too. Heartbreaking. Yeah. Fire's good moving. Yeah. Go back and watch it. It's good. Patty, great question. Says, do you think she'd be released on bond if a new trial is ordered? Well, she was out on bond, awaiting trial. So I do. If it is found that she was not given a fair trial, that her constitutional right to a fair trial was violated by the actions of Juror 15, because I absolutely think, what argument is the state going to make? We would have allowed this person on the jury had we known? Of course they wouldn't. They wouldn't have. Not even they would have wanted this person on the jury. I think there's a good chance she could be released back out on bond. Exactly, Christian. Give the jurors a complete video of the trial and let them rewatch the whole thing if that's what they want. Right. Should we throw pizza at them and some soda and let them go until 10:30, 11 p.m.? Or should we let them take their time and review what they want to review, because we're really looking for justice and we're looking for what the testimony actually was, not some made up BS in the prosecutor's closing and rebuttal that none of that evidence was entered into trial about Doug filing for sole custody. None of us heard that. Esme says Griner, Whelan, and all others just show going to Russia isn't safe as an American or European. Jim Morrison remembers that movie. That's what it was, Broke Down Palace, which is also the title of a Grateful Dead song, which is why I remembered it. I wonder if they named it after the Grateful Dead song. The person who wrote that was a Deadhead. I wonder. Toy Thomas says, don't take anything, buy new everything when you get there. Thank you, Janai. Broke Down Palace, right? That was it scared me for life. I think we should make all of our kids watch that movie. I think I'm going to do that tonight. Terry's like, Thailand's not the place to smuggle things into. Tracy Burns, I've been in the Czech Republic and the Czechoslovakia for 30 years, and the police have helped me at least 7 times. That's great to know. Sounds like a safe country. May Cronin says, it seems like the judges need to explain the law pertaining to the case in detail. Yeah. Instruct them on the law, right? Explain it to them, not teach them the law like Judge Canoni wanted to do. Mel says, yeah, people should learn what is or isn't allowed in foreign countries. Crow Red, I said that movie affected me too. Max Bang, I saw that movie. Yikes. Exactly. Okie dokie. It can be any country depending on the day and the infraction. The young lady, back to the Russian ballerina, has dual citizenship in the US and Russia. She donated the money in 2022. Treason? Okay. Lou Jones says jurors need to know what they're entitled to ask. I agree with you. In Dubai, certain over-the-counter medication is illegal there, says Miss T. That's good. Thank you. Love how you guys give each other tips. Pilgrim Shadow. I figured people get sick of my Grateful Dead quotes and reminders to pray. No, it's my channel. I love it. We're not cupcakes. We can't please everybody. We can't make everybody happy. Pilgrim Shadow. Thanks for your other 5. Broke down Palace, right? Crazy. David, I saw on the Young Jerks the other day, someone was complaining about you ran a toxic platform. Well, who? Who was complaining about me running a toxic platform? Thanks. Thanks for pointing that out. So now I can stress out about it and go look for it and find out who it was. But like, I don't know what you're talking about. Somebody in the chat? Oh, probably somebody that I blocked because they're a troll. That my platform is toxic? Okay. Probably a fan of, I don't know, some other people who actually are toxic on the internet. Okay. That's cool. Young Black economist, when I heard about Americans doing things abroad that were told specifically not to do during Peace Corps training, I just shake my head. I know. Why? Thank you, Melissa, for pointing out that my channel is far from a toxic platform. Thank you. Thank you so much. It's because I'm not afraid to say what my opinions are. I'm not a robot. I don't use a robot voice and play videos. Some channels play trial videos and don't even come on camera. They just restream somebody's the trial from another. How fun is that? I mean, what is that about? Thanks, Deanne. Thank you. Oh, look, even Broken Baker. Everyone is toxic to someone on YouTube. Exactly. Exactly. Of course, they disagree with you on your opinion on a case, and they come for you. They come for you personally. Magnolia Gypsy said, I've never seen that in the Young Turks. I don't know. I barely have time to do my own shows, so I don't always have time to watch other people's shows and chats. But toxicity is not something that I fall prey to, and I'm not afraid to block people who bring their toxic BS here, because hate sells. There are some people who just run hate channels, and I'm not here for that. Thank you, Jadzia. New Hampshire was crocheting a poncho, and it's sunny in Colorado today. 360 days of sunny year. Kayla says, I appreciate there's a trauma-informed space to watch these trials. Thank you. Thank you. Just because I have sympathy for people and empathy for people and people's situations, and I have so many survivors in my chat. Should I have done the, more popular thing and attacked Ashley Benefield? I'm going to always stand up for what I believe in. And if people don't like it, they don't need to watch my coverage. They can go watch someone else's coverage that they agree with. Maybe they'd be more happy there. And, they don't need to spew the BS and attack people. Thank you, First Class Chris. Appreciate you too. I absolutely love you right back. Every single one of you. All right, you guys, I have the indictment pulled up on the K Queen out of North Hollywood, California, who has been indicted in the overdose death of Matthew Perry. If you guys are interested in a stream on that, let me know. It's wild. 5 people were federally indicted in the overdose death of Matthew Perry, and 3 of them have already taken plea deals. There is 1 doctor And one beautiful woman, by the way, who is called the K Queen. Can't say that K word on YouTube, I don't think. But if you remember the Maya trial, you know what K is. And it's wild. The indictment is wild. I mean, they were ripping him off and selling him all kinds of drugs that were like worth $12. Tens of thousands of dollars. Yeah. The Ket Queen. Yep. All right. You guys want to hear it? I'm here for it. All right. Make sure you have all notifications set because it's a long indictment and it's really, really interesting. And that book is really heartbreaking, Zimmy. I agree. Yeah, the indictment is wild. And this woman is being held without bail. And she's beautiful. Her Instagram is still up. And she really lived a lavish lifestyle. And when they went into her North Hollywood pad, they found all kinds of things cooking on the stove, if you know what I mean, and all kinds of things. Thanks, Cancel Dude. Press 1 if I'm totally non-toxic. I think that is Sean McDonough doing a show today at 4:00? I think he is. Let me just see. Because if he is, I'll tell you to go watch him. What's the schedule tonight, my friends? You guys know. I mean, I would love to do another Karen Reed show, but I feel like there's just nothing to talk about right now unless we just want to like commiserate with each other. Happy to do that. 4 p.m. Going Through the Motions is the name of his channel. He will be live at 4 p.m. Thank you for all your ones in the chat. You guys are so awesome. Linda says, I'm still blown away at the amount of people who see her as guilty. Yeah. Yes, Nosy Rosie. The 2 doctors in the Matthew Perry case are still able to prescribe. His own assistant, the guy who took a plea deal, Mr. Iwamasa, shot him up like 6 times with K on the day of his death. And then during the hot shot, or the shot that he gave him where Matthew Perry said something like, give me a big one or something. The assistant then went out to go run some errands, and that's when he came home and found him dead in the hot tub. Horrific. Yeah. Thanks, Pilgrim Shadow. The moron quote was horrendous. Charged $2,000 for a $12 vial. Mm-hmm. The street value is about $100, says Wednesday. Press down if Melly's the best. Woo! You guys are sweet. You're very sweet. Ellen Greenberg, I'm definitely going to cover Ellen Greenberg. Just not right this second, because I try and cover stuff that's happening at the moment, like Donna Adelson, but that's not coming up right now. So we'll do that as it gets closer. Little Miss Red Velvet. Hi, I'm back. Hello. Hello, Jill. Please ignore these people say ridiculous things like toxic. Your channel has helped me so much through difficult mental health, called Angel Channel by me. Oh, thank you. Thank you, Jill. Welcome back. I don't know if we're allowed to stream these movies together and watch them. We can do homework and then watch them and then discuss them. I don't have Discord. I don't have Discord. I don't know what goes on Discord, and I certainly do not need any more Discord in my life. So just the name makes me want to shy away from that. Mandy, thank you for tuning in from South Africa. In fact, when we complained about toxicity on Law and Crime, we were told to come to your chat for quality viewing, and I became a member. Thank you. Thank you, Mindy Stone. Thank you so much. It's so sweet. Yeah, some of them, 3 of them did take pleas. There were 5 arrested, 3 took pleas. Probably going to roll over on the other. And I think a lot of people in Hollywood are really worried about the K Queen's Black Book and who her other clients might be. Just saying. Because, I mean, since we're here, I'll just show you something that I found when I went to her Insta. I don't know if it's still up, but I did take a picture of it so that I could show it to you. And it was not something that she posted. It was something she was tagged in. So take a look at this. This is from March 7th of 2022. Somebody posted this. This is the K Queen on the right here. Is that Charlie Sheen? Because that looks to me like Charlie Sheen. I was looking at it, I'm like, it kind of looks like Charlie Sheen, but then maybe it's not Charlie Sheen. Maybe it's a Charlie Sheen impersonator. Says it's always a family affair when we do it. I think that's her brother. March 7th of 2022. And what say you? Thank you, Mom Michelle, for the 20. Says, at least talk to channel on these nasty YouTube streamers. We love our Mel. Thank you. I love you too. I love you too. Mrs. Jim Morrison, where are you? You had a good comment here. Where is it? So I read an article that K is used to reset the brain for people that suffer from addiction. Obviously, it would not be handled like this case. Yes, and I did a stream with Dr. Kave during the Maya Kowalski trial. Dr. Kave has a channel called Medical Secrets. He runs a K therapy clinic, I think in San Francisco. And we talked about how it can be helpful for people with addiction, PTSD, depression, but it has to be dosed by a doctor. And what happened in this case is that apparently Matthew Perry they wouldn't give him any more K therapy treatment at his doctor's office. And so he went the illegal route. And there was one doctor, the one who is still under indictment, who was teaching his assistant how to inject it and then selling it to Matthew Perry and calling him a moron. Wonder how much the moron will pay for it. It is Charlie Sheen. Think so? I'm just saying. Brooke Mueller was investigated. I think she also helped Tammy with the investigation in this case, right? For those of you who don't know, Brooke Mueller was married to Charlie Sheen. They had children together and a very toxic relationship, drug fueled, the whole thing. I don't know if Charlie Sheen is sober now. I don't know. But it does look like him. And I think a lot of people in Hollywood are really, really afraid of K Queen's Black Book coming out. So who knows? This is her on the right-hand side here. Name is Jasmine Sangha. So let me check out my schedule. Maybe we'll do a show on that later tonight. I'm going to check out the schedule of who else is doing what tonight so that you guys will come back and watch it here. Tomorrow, we are going to cover going back to Vegas for the Robert Tellis trial. And I think we're on, what are we on? Day 4 of that trial or day 5? And we've already heard from almost all the witnesses. So this murder trial is flying by. We're having a great time over there. So come and join the band. Somebody said it looks like Jason Bateman. Oh, this one, that's her brother. That's Jasmine Sangha. That to me looks like Charlie Sheen. I cannot confirm or deny. Right. It can be used under IV under very controlled medical conditions. Right. Dr. Kave, Medical Secrets, has a good channel. He seems so kind. Did anybody watch that show that I did with him? All the way back when we were covering the Maya Kowalski case? It was a great show. He schooled us. Phoebe says, I don't think the doctors in Matthew Perry's case will be able to practice medicine after this. They'll surely lose their licenses. I watched a dentist charged with perjury last night, and he lost his license. Oh, you really went for a really more mild trial this time, Phoebe. Good for you. Back to Boss Baby, and his facially, he does look like Boss Baby. And he was nicknamed Boss Baby by his employees who claimed toxic workplace and filed a federal lawsuit against the county and against him in his official position as the public administrator. We haven't heard any of that testimony because I don't think it's coming in. Queen Rose Red, those of us who have been DV victims should raise their hand in chat. I'll start. Some people may not want to talk about it, but if you do, you will find that you do have a lot of support. A lot of support in this chat. It was his employees who named him Boss Baby, and then I ran with it. They're calling it, what are they calling it on other channels? Like the Vegas reporter trial, because it was a Vegas reporter that he allegedly murdered, but I'm calling it the Boss Baby trial. And I put the little Boss Baby, and we made a Boss Baby emoji. Check it out. I'm going to put it in the chat for you guys to encourage you to come watch the trial with us tomorrow. We have Boss Baby emojis for this one because we did the same thing like we did for Karen Reed. We created some emojis. So here's Boss Baby. There's Boss Baby emoji. And I also made a WD-40 emoji because the courtroom door in that courtroom is really, really squeaky. So WD-40. And then, except maybe they did WD-40. Maybe they were watching. And then the giant straw hat that he was wearing, or the perpetrator was wearing when they went to Jeff Gehrman's home to kill him. They were caught on video wearing this crazy costume, like a giant straw hat, an orange reflective shirt, and jeans, and these what one witness who described himself as a fashionista, Zachary, said were those cheap kind of Nikes that you get from Marshalls or Ross, so with the plastic top instead of leather. So I knew when I saw those shoes on TV that was definitely Robert Telly's. It was crazy. I'm gonna put the DV hotline on the bottom here for a moment. I forgot that I forgot to put that on there earlier. But if anybody is in a situation and you need help, please call this number. It's 1-800-799-SAFE, 1-800-799-7233. And they have been a lifeline for many people in this chat. And we also have boarding pass emojis because my mods are not afraid to give out boarding passes to trolls on a one-way flight the hell out of here. So call it toxic if you want, but it's not. All right, make sure you hit the subscribe button. Make sure you hit the bell so you'll know when I go live on the Matthew Perry indictment, or the indictment of the K-Queen, actually. Jasmine Sanga, maybe later today, maybe tomorrow morning before we go to trial at 1:15 in Vegas. So you don't want to miss it, maybe. And moderators, thanks for keeping it classy tonight. I think we had a pretty good crowd here that was nice to each other and kind and respectfully disagrees. So if you don't disagree with me, come for me in the comments, my comments, not on the cesspool of Twitter because I'm not there. My comments, respectfully, and I'm happy to engage with you in a respectful way. If you're not respectful to each other and to my moderators and to me, then you get a boarding pass out of here. It's really that simple. And if that's toxic, well, I'll take it. I've been called far worse. Trust me, I've been called far worse. Thank you to the members who love me enough to join my channel. Watch out for the full moon, everyone, because it's real. The full moon energy is real. And if you guys wouldn't mind hitting the like button, we've got over 1,600 people in here, which is a nice crowd for a Sunday with only 1,000 likes. So if you guys would hit the like, it really helps push the stream out. It really helps the channel. Feel free to share. Feel free to, do all the YouTube-ish things that YouTube likes you to do. The subscribe button's free. The bell's free. You might want to stick around because we have a lot of fun here and our chat is amazing. And as I always say to end every stream, just be cool, be kind, be classy. It's not hard, really. It is so not hard. I love you all. Peace out. Have a great rest of your Sunday. Maybe I'll see you over at Sean's at 4 p.m. Enjoy, everyone.